came up with is this list of recommendations. This report, by the way, is the report we did. It's available on our website. But this is a list of the recommendations that we ended up coming up with. And it turns out that DA Vance actually was doing many of these things already. And some of them he was doing partially, so that we recommended that he do, to a greater extent. But a lot of these things he was doing already, to his credit. So we recommended, the first thing we recommended was applying blind fundraising standards, and this goes back to what New York State judges do. The idea being that a district attorney candidate, whether a sitting district attorney or a challenger, should not know who is giving to him or her and how much. So they just kind of stay out of that whole process. And this is difficult to do. It requires a real kind of strict separation between the office and the campaign. The DA obviously could still be involved in kind of strategy stuff with the campaign and making policy statements and the like, but shouldn't kind of see the checks coming in, right? Shouldn't see lists of all of that. Now, obviously, all of this information is public on the Board of Elections website, so I've heard a lot of people say, like, that's so silly. I mean, they could just go online and look. That's true of the judges, too. It's also true, though, that, the information is still all coming into their campaign. So not only could they get online, but in theory, they could just access the information from their campaign. But, you got to trust them to some extent, right? You have to assume some good faith here. And the process seems to work fairly well for the judges. It's a clean solution. It's a simple solution. If you don't know who your donors are and what you're getting, you can't be influenced by that, consciously or unconsciously. So we recommend that. The one caveat that we put on that was that we thought it was too strict to not allow district attorney candidates to attend their own fundraising events, even though it means that when you walk into a fundraiser, you see Joe and Mary and Tom, and therefore you know that they at least bought a ticket, which means that they've contributed. We just thought at the end of the day it was too much to say that they couldn't even do that. So it's not a complete 100% blinding, but we thought that was a good compromise. The second recommendation that we made was to refuse or limit contributions from parties with actual or potential conflicts. And this is the one that involves a lot of line drawing, which means it's fairly complicated because you have to kind of put different donors into different buckets and figure out who has the conflicts, and then we had to come up with some suggestions about what these limits would be. And many of these District Attorney Vance was already doing. Like, they already were checking to make sure that no parties to matters in the office were donating. So a criminal defendant, someone with a bench warrant, anyone who kind of would pop up in the system, they were already running those checks to make sure that those people were not donating. So we recommend that for all DAs. We also, though, recommended a limit on the lawyers who represented people in front of the office. And this is what was really new. All of this requires a decent amount of work on you call it the IT side, right, or the paperwork side. It means that you have to be taking your donor lists and checking them against your computer systems, your case management systems, to figure out the answer to this if anyone is giving. It requires some work. It's doable. If it's doable in an office the size of Manhattan's office, I think it's doable everywhere. I also was told that for smaller DA's offices, DASNY has case management system software that they provide. I think there are ways to get this done, but it does require work. So the way that we suggested it should work, as we kind of thought about what these limits ought to be, is we took a look at the city's doing business regulations and their campaign limits. You have to find a number somewhere, and we wanted to not just pick an arbitrary number out of the sky, so we looked at those limits. And what we ended up recommending is that for lawyers who are actually in front of the DA's office with a case, that they be limited to $320 as a donation. And that is the amount that a person who's doing business with the city can give in the borough president's race. We chose that elected official in the city because it's a county-wide office, like the district attorney. And we then thought about what to do about law partners who share in the profits of the person who's actually in front of the office. Because of that financial interest, we thought that they should be limited as well. So what we ended up recommending for that is we took the number that is the non-doing business number. It's the general contribution limit for the borough president's race in New York City, and it is $38.50, I think, $38.50. So that's what we came up with. People can argue about whether those are the right numbers or not. It seemed to us that $320 is not enough to be tempting for a DA to change his or her decision on something. But we also didn't want to completely ban lawyers from giving, not only because lawyers are typically a big donor base for district attorneys, but for good reason they want to give. We think that criminal defense lawyers and lawyers generally have a real interest in having a DA who's fair and capable and smart and all of those things and efficient. And so they should be kind of cut out of the process there, or at least not entirely so. So we also felt, though, that for smaller counties that those limits were too high because we have a chart in our report that kind of gives some comparisons, but as you go down in size for the counties, you really do see a decline in kind of the average contribution amount and the total amount collected. So these numbers are going to be too high, too influential in smaller counties. So for that, for those smaller counties, we recommended a 1% and 10% respectively numbers for that, which is about what the $320 and $38.50 are for the large counties. We had to also pick a number for the time period that would apply. So if someone has a case, a lawyer has a case in front of the office, at some point that case will end. How long after that can they give again? Can they turn around the very next day and say, here's $5,000? So we said 6 months was a good period of time. So your case ends, 6 months go by, you now can give without being in the bucket of having a case in front of the district attorney's office. So that's what we said, and suggested that older donations should be like a case-by-case basis. So if you see someone coming in with a donation and you look back and say, well, it's been 6 months since their case ended, but it was an enormous case, it got a ton of publicity, maybe we should say that we don't want to take this donation anyway. So the other recommendations we made are more of a collateral nature. Enforce a strict division between the campaign and the office. That's necessary for the blinding provision. It also just makes good sense and helps DAs comply with the rules about not using government time to campaign and that sort of thing. We recommended refusing campaign contributions from within the DA's office. As many of you know, city DAs are already prohibited by the Conflicts of Interest Board from doing this, but it is actually a practice in some upstate district attorneys' offices to collect from inside the office, which we just think is a bad practice. We recommended utilizing a comprehensive vetting procedure. DA Vance already had a vetting committee in place, which we thought was a good idea. We recommended, though, expanding the process, making it more formalized, especially if there's going to be blinding in place where the DA is not going to be kind of the final arbiter of whether to take a contribution or not. You certainly need to have someone playing that role who you trust, and you trust that person's judgment and so on. We recommended requiring a certification form for donors. That could be kind of your first check to try to see that this person and this donation is in compliance with all of your policies. The Vance campaign had such a certification form, so we took a look at that, and then we added some things to make it in line with the rest of our recommendations, but we recommend using that. And finally, we recommended publishing the campaign policies. We just thought that would help with transparency and accountability. It would help with the donors themselves understanding which donations are and are not okay with the campaign. And it'll help public perception, right? So the press and the public can see that the DA is serious about avoiding these conflicts and trying to keep all of that above board. So that